Judge humiliated a black female legal intern in court, then she uncovered the evidence that destroyed his alibi. Naomi Waters was not the kind of person who made noise. She made notes. Every morning she arrived at the county courthouse 40 minutes before anyone else. She would sit at the far end of the prosecution table, arrange her folders in order, and read through every document in the case binder twice. She was 24 years old, 3 months into her legal internship, and she understood very clearly that the job of an intern was to observe, to learn, and to stay out of the way. She had been told this on her first day. She had not forgotten it. The city she worked in was the kind of place where old names carried old weight. Families who had been connected to the courthouse for decades still shaped the way things moved, quietly, the way water shapes stone. Naomi did not come from one of those families. Her mother, Gloria, had cleaned office buildings for 30 years. Her father had left when Naomi was 7. She had put herself through college on 2 scholarships and a part-time job at a grocery store, and she had earned her place in law school through nothing but stubbornness and late nights. She knew better than anyone that people like her did not get second chances when they made mistakes. So she did not make them. The case she was assigned to that October was a property fraud matter, not exciting, not complicated, but important. A developer had filed documents that were believed to be tampered with in order to push through a construction approval. The prosecution team was led by Assistant District Attorney Helen Park, a precise, careful woman in her 40s who liked things to be neat. Naomi liked her. Helen did not waste words. It was during her second read of the morning binder, on a Tuesday, that Naomi noticed something. There was a court continuance form tucked between 2 exhibits. It was a small document, easy to overlook, the kind of paperwork that gets filed and forgotten. But the timestamp on it caught her eye. The form showed it had been signed and approved inside courtroom 4B at 10:47 in the morning on a specific date in March. Naomi noted the date, looked at a separate document in the same binder, a scheduling affidavit, and felt something go still inside her. The affidavit had been filed by the presiding judge himself, Judge Carlton Voss, as part of a routine scheduling disclosure. In it, he stated under oath that he had been traveling to a judicial conference in Denver on that same morning in March, departing on an early flight at 9:15. Naomi sat with both documents side by side for a long moment. Then she wrote down the date, the timestamps, and the flight time on a separate piece of paper and placed it in her personal notebook. She said nothing yet. She simply wrote it down. Judge Carlton Voss had been on the bench in courtroom 4B for 19 years. He was 61, silver-haired, and walked with the kind of slowness that powerful people use to remind others they are in no hurry. He had a reputation for being exacting. His courtroom was always quiet. He did not like disruption, and he did not like what he considered incompetence. Most people who worked in that building were careful around him. Naomi had been warned about his moods on her very first week. She had seen him be short with junior attorneys. She had seen him dismiss a court clerk's question with a wave of his hand as though the man were a fly. She had filed these observations alongside everything else she noticed. She did not allow herself opinions about people she did not yet have enough information on. That was something she had taught herself a long time ago. The afternoon session began at 2 o'clock. The gallery had a handful of observers, 2 defense attorneys sat across from Helen Park, and the bailiff stood near the door. Naomi was at her end of the table, her notebook open, doing what she always did, watching and writing. During the first recess, at 2:14, Naomi stepped into the front area of the courtroom to pick up an exhibit folder that had slid off the edge of the table. It was her folder. She was allowed to be there. She bent down, picked it up, and turned back toward her seat. Judge Voss had returned early from the recess. He stopped when he saw her. He looked at her for a moment with an expression that was hard to read, something between irritation and dismissal. Then he spoke, in a voice that filled the room. He said that he did not know what law schools were teaching these days, but that in his courtroom, staff knew their place. He suggested that she consider finding hers, somewhere, he added, with better judgment and a sharper pencil. The court reporter's fingers stopped moving. The bailiff looked at the floor. One of the defense attorneys shifted in his chair. Naomi stood completely still. She did not look away from the judge. She did not respond. She walked back to her seat, sat down, opened her notebook, and wrote down the time, 2:14 p.m., and every word he had just said. She wrote them in quotation marks, exactly as he had spoken them. Then she drew a small line under the entry and moved on. Helen Park did not look at her. That evening, Naomi did not go home when the others left. She stayed at her desk until the building was nearly empty and she had two things in front of her, the continuance form and the scheduling affidavit. She opened the court's public records database and looked up the judicial conference in Denver. It was listed. She found a local newspaper article from that same week that mentioned attendees. She cross-referenced the hotel listed in the expense report the defense had submitted as a routine case exhibit. The hotel check-in showed arrival at 3 in the afternoon. She pulled the courthouse's public access visitor log, a standard document available to anyone who requested it, and noted that it recorded keycard entries for authorized personnel. She submitted a written public records request that same evening, before she left the building. She did not sleep well that night. Not because she was afraid, but because the shape of what she was looking at kept arranging itself in her mind. A signed document placed in courtroom 4B at 10:47 in the morning. A sworn affidavit claiming the signer was at an airport at 9:15. A hotel check-in showing arrival in Denver at 3 in the afternoon. A keycard log that she had not yet seen but had formally requested. She was not jumping to conclusions. She was following a line. She brought it to Helen Park the next morning. She laid the papers out neatly, pointed to each discrepancy in order, and explained her reasoning calmly and clearly. Helen listened. She did not interrupt. When Naomi finished, Helen looked at the papers for a long moment, then closed the folder and pushed it back across the desk. She told Naomi this was above her level. She told her some things in a courthouse were more complicated than they looked from the outside. She told her, and Naomi would remember this sentence for the rest of her career, that this was not how a person started their life in law. Naomi thanked her and picked up her folder. That night she called her mother. She did not explain the details of what she had found. She just asked her a simple question: if her mother had ever found something wrong at work, something that actually mattered, would she have said something about it? Gloria Waters did not hesitate. She said she had spent 30 years cleaning up other people's messes and had never once gotten to decide which ones were worth fixing. She told her daughter that she had that choice. She told her not to waste it. Naomi filed a formal complaint with the State Judicial Conduct Commission 3 days later. She attached the continuance form, the scheduling affidavit, the hotel check-in record, the newspaper article, and a 6-page written analysis she had composed herself. She signed her name at the bottom in full. She kept a copy of everything. The pushback came quickly. Within 2 weeks, she was informed that her internship placement was under administrative review. She was quietly moved off the fraud case and reassigned to filing duties. People who had spoken to her easily in the hallway suddenly became very busy when she walked by. A note appeared on her desk one morning, and signed, typed on plain paper, that said she should have stayed quiet. She put the note in a new folder and labeled it. She also began a second log, a precise, dated record of every professional action taken against her since she had filed the complaint. She wrote down names, times, what was said, who was present. She did not express opinions in the log. She only recorded facts. It was the same discipline she applied to everything else. The keycard log arrived in response to her public records request 6 weeks after she filed it. It showed that a keycard registered to Judge Carlton Voss had been used to enter the courthouse at 10:31 in the morning on the date in question. She added it to the file. The Judicial Conduct Commission had been slow at first. These things moved carefully, and they moved carefully for a reason. Accusations against sitting judges were serious, and the commission was careful not to act on incomplete information. But Naomi's submission had been thorough, and it had opened a door that others walked through. A retired court clerk, a woman who had worked in the building for 22 years before stepping down, contacted the commission. She had heard, through the quiet network of people who had spent their careers inside the courthouse, that a complaint had been filed. She had information of her own, 2 other instances, across different cases over a period of 7 years, where paperwork had not lined up the way it should have. She had noticed at the time. She had said nothing. She said something now. A local journalist who covered the courts received an anonymous tip and filed his own public records request. The keycard log became part of a news story. A handwriting expert hired by the commission reviewed the signature on the continuance form and confirmed it matched Judge Voss's signature on record. The investigation moved faster after that. On a Thursday morning, 11 months after Naomi had stood in courtroom 4B and heard a man try to make her feel small, the story ran on the front page of the regional newspaper. Judge Carlton Voss was placed on administrative leave. The headline used language from his own falsified document. Naomi read the article at her kitchen table. She read it twice. Then she set it down, finished her coffee, and opened her case notes for the day. 18 months after the complaint was filed, the state Supreme Court removed Judge Carlton Voss from the bench. The Judicial Conduct Commission submitted a formal referral to the Attorney General's office recommending a criminal investigation into perjury and obstruction. The courthouse updated its document authentication procedures, citing gaps in the existing process that had allowed the irregularities to go undetected. Naomi completed law school the following spring. She passed the bar exam on her first attempt. She accepted a position at a nonprofit organization that handled civil rights cases where people who had no money and no connections needed someone who understood exactly how easily the powerful could misuse paper, and exactly how much damage a careful person with a clear record could do in response. On her first day at the new job, she unpacked one small item from her box and placed it on the wall above her desk. It was a piece of paper in a simple frame. The paper was the typed note someone had left on her desk during the darkest weeks of the investigation. It said she should have stayed quiet. She thought it was the best reminder she had ever been given. Not because it frightened her. Because every single morning, when she sat down to work, it told her exactly what kind of person she refused to be.